Yes, welcome to another edition of the No State Project, live from my YouTube channel, No State Project. Oh, that's pretty cool. We actually had people waiting for the show to start. So, hey, appreciate that there, guys. It is actually February 1st, 2020. Wow. It's already February already. And so much has already happened in the first month of 2020 at Australia, is still on fire. So much to get to. I appreciate everyone tuning in. I'll give the caller number is in the show note, so I will give it out, but if you want to just copy and paste it and put it into the chat there, the Skype, the YouTube chat, then please, by all means, do that. That's less time that I have to spend giving the number out. But it is 717-2. I have to change that on the website, too. So markstevens.net. I haven't put the new call-in number. And so someone's saying, you color your hair? I don't color my hair. What do you... I don't color my hair. It's just the front of it is still black. I color my hair. There's nothing fake on the show. No, I don't color my hair. I have very precious little in there that's still black, but it's still maybe a little bit wet. So that might be what is throwing you off there. But I used to have all jet black hair. My eyebrows are still so that's I'm glad for that. But as a Sicilian, what I haven't told is that as a people, we tend to go gray earlier. So this actually started when I was 17. So it's been a while. Hey, I'm glad I still have the majority of my hair. I think I got 85% of what I started out with. So, hey, I'm happy for that, especially when I got family that they don't. So for whatever reason, 20 years ago, the men stopped retreating. I'm very grateful for that. But I was giving the number out and I noticed that. So I need to get the webcam and the straight. I wish I was able to do that. All right. Anyway, it's 717-275-8941. The passcode is 123-3428. And that'll get you into that there queue. And it looks like we've got somebody in there already. So I may have to just do the intro stuff and go straight to that. But then I got to put the headphones on. Oh, what you people do to me? How much can you expect from one person? Mark, please give example of facts as in what? Oh, I'll get that in a second, Rex. Skype is Frank Rizzo 3. Instant message me first, and then we can get you up on that there broadcast. So as far as I can tell, nobody is looking to do that just yet. But Frank Rizzo 3. So my dog Rex is saying, Mark, could you please give examples of facts, as in what facts do you rely on upon that prove that the code applies to me? Could a fact be a contract? Well, if you're looking at someone like Donald J. Trump, the impeached president, then yes, you can go to, I don't know if you can really say it's a contract, but you can point to the oath of office to preserve and protect and defend the Constitution. That would be at least prima facie evidence that the code applies. What I'm talking about, I have to show this one. Please stay away from the sovereign citizen types this way. Well, we'll see if I have to debunk it, I will debunk it. I'm happy to bring facts, contradicting facts and logic and an argument to show that people shouldn't be engaged in that stuff. Okay, why somebody who's a sovereign citizen type would be attracted to an anarchist show? I don't get why people are talking about the right to travel. Obviously, they're new to the show and haven't been necessarily exposed to the facts and the logic that debunks that stuff. So as far as the plebes are concerned, people, the little people like me and you, I'm not asking the question because I think that they have facts to actually support it. I'm asking the question because at that point in the line of questioning, I'm bringing out a contradiction. I'm bringing out the fact that they are not able to produce any facts. We already know that they believe that if I'm physically in Arizona, their constitution, a written instrument, applies to me. I just want some facts to show that that's actually true. The best that they can do is to just say, well, dude, you're here. You're here. Or if you are like, if you're educated, then you say, like what Scott Bales of the Supreme Court in Arizona says, that the people that we've prosecuted and put in prison before you, that somehow proves. Of course, when I followed up and asked him in the rotunda, because they wouldn't let me do that on camera anymore, he refused to answer the question. Exactly how does putting somebody else in prison prove that it applies to me? Of course, he couldn't answer that. Again, that's the Supreme Court Chief Justice at the time couldn't, although there are people on the internet think they could do a better job. So, but for some reason, they don't call into the show. And so what we're doing is we're calling out there, we're calling a bluff, if you will. Most people assume that it's true. Well, if you're physically here, that's the way it works, okay? That's just the way it works. How so? That's just the way it works. It's the way we do it. I'm a fungal with your logic and your evidence and burden of proof. That doesn't apply. Take it to the legislature. And if you don't get the answer you want from the legislature, vote them out or shoot them. That's your only option. If you don't like that the law applies to you, vote them out or kill them. That's pretty much it. So the questioning, we know in advance that just because men and women force people in the community to give them money, that's no evidence whatsoever that their edicts and their rules apply. And because of that, when we're asking them to support their claim, we know in advance they can't. That's why they generally will say, well, it's an assumption. Go listen to the Call of Shame from last year with the tax counsel for the Franchise Tax Board in California. He very clearly agrees that their determination, their legal claim that the laws apply because you're physically in California or because you earn money from a California source, that it's an assumption that the laws apply because of that. It's not because they have any evidence. It's not because they have any facts, any logic. It's an assumption. I remember, this isn't some big mind-blowing thing that I created, but I will point out every week, if you start from an assumption, you cannot prove your proposition beyond a reasonable doubt. There you go. So we're just calling BS. That's all we're doing when we are challenging their assertion that the laws apply. Calling a bluff, if you will. They just bank on good little citizens, good little plantation workers to just accept. Well, if the legislature says, if they say the laws apply, the laws apply. If you don't like it, you got to kill them. I'm not advocating that, by the way. That's something that someone on YouTube is advocating. And the only thing you can do is you can vote them out or you can kill them. You either got the ballot box or the bullet. That's it. I disagree. I think you can question the argument or the claim that's being used against you. This false dichotomy. Well, you can, all you could do is vote them out or kill them. That's all you could do. Now let's use our brains. And if you doubt that it's successful and that it's effective, that's great. Be a skeptic. I'm all for it. I got plenty of evidence at markstevens.net under the success stories. I got 3 I'm going to get posted this week. I keep saying that, but I'm going to do it. Okay, so what we got to do over here is I got to put the cones on. I got everything. All right, here. My daughter likes to take these to school, and she's got a much smaller head. She's a little tiny thing. All right, we got that there, area code 667. You're live on the No State Project. What's your name? Where you calling from?
Hey, Mark, this is Roy here from Virginia.
Roy, I think I already know you don't have good news for us, right?
Yeah, yeah. Judge steamrolled me again.
All right. Well,
So
I know
this
the
time,
details. Why don't you
basically,
lay the details out for those listening?
okay, basically, I asked the judge, is the court is this court bound by the Supreme Court rulings in the Constitution? He said yes. And I asked him, am I entitled to a fair and meaningful hearing? He said yes. And I asked him, am I presumed innocent of every element? I asked if I presumed innocent of the charges. And he said yes. And when I got to the question, am I presumed innocent of every element of the charge? He just went on this legal diarrhea, and I came back to him. I was like, objection, Your Honor. It's a yes or no question. Am I presumed innocent of every element of the charges? And he just went on this tantrum, and I'm like, objection, Your Honor. It's just a yes or no question. He was like, and this is where he messed up at, because he's like, he was going to be presumed. And once I brought him back to the question one more time, he said, you know what? Yes to all your questions. And so basically, my next question was, is jurisdiction an element? So he said yes to that.
Sure.
But as soon as I tried to get to that question, he just ignored me and overtalked me. So I just be quiet. And so I was quiet. Then he let the cop testify. And I objected. I said, objection, Your Honor. How does the cop testimony prove that the Constitution and laws apply to me just because I'm physically in Pennsylvania?
Oh,
and he was
dude.
like, overruled.
Well, that's because our objection, what I would do is I would object on grounds, especially since I've already gotten the discovery request that probably has not been responsibly answered and complied with. I would object on grounds that the police officer has offered no proof of personal knowledge of the matters they're testifying to under Rule 602, which is the federal rule that is usually adopted by the states. And the states that haven't adopted federal rules, like California, the rules of evidence still pretty closely mimic that. And it's the same in if outside the United States, that they have to have personal knowledge of the matters they're testifying to. So that should be the main objection when they're going to put the police officer on the stand. And because your objection was kind of premature on that. I would have hit him first with the lack of proof of personal knowledge.
Okay. All right. And then basically it was overruled. And so when these cops showed the video, I objected to it, and I was like, objection, and he was like, overruled again. So he was just basically overruling me. And when I got to examine the cross-examine the cop, which is basically the judge assumed the burden of proof for the officer again, because I asked him, did you witness me violate the laws of the state? And he said yes. And I was like, did you make a legal determination that since I may have the question wrong, but I was going by the script. And I said, did you make a legal determination to stop me when I violated the laws? I'm just summarizing. And he said, yes. And I asked him basically like, what facts did he rely on? I know I'm missing a question, but I asked it too. But when I asked him what facts did he rely on, the judge intervened for him, and he was like, he already answered that question. And basically, what made me upset was the bailiff was smiling. When I asked the cop, when I was cross-examining the cop, and I asked him this question, the cop had a smirk on his face. So basically, I guess he knew the cop was going to cover. I mean, the officer. I mean, not the judge is covering for him.
Yeah. So let's see if we got this right. You asked him about the legal determinations, and he said yes. When you asked for the facts, the judge jumped in and said that he'd already answered that question.
Yes.
Did you object and say no? And if you disagree with me, sir, could you please tell me what specific facts he testified to? Because I never asked that question.
Basically, he just kept over talking when I tried to object, and then he was like, do you have anything else? Basically, he was just like pushed me out the way, and he was like, if you don't have anything else to ask the officer, he's going to sit down. I was like, objection. He haven't answered my question. You assume the burden of proof for him. And then when I tried to ask him a question again, the judge was like overruled, and he set the cop down. So basically, there was no effective way to defend myself. But at the moment, I was thinking, what I should have done was said objection. I should have told the judge objection. I should ask the judge, are you saying that the cop is not qualified to make a legal determination? That's what I should have asked the judge on the objection.
I don't think
I wasn't thinking at the time.
I don't, but from what you're reporting to me, it doesn't seem like you had the opportunity to do that. What you had was a judge running interference by not allowing him to answer the question on different grounds. 99% of the time, the judge and the prosecution will jump in and they will object to the question on grounds that it calls for a legal conclusion, which is a violation of the ethical rule 3.3 of candor towards the court, the tribunal, because they're lying. It's not because you asked a question for the facts, not for a legal conclusion. So they're lying. You didn't get that here. So he's not questioning the competency or credibility of the witness. So here what you had was a tried and true legalistic douchebag move. Asked and answered. Asked and answered. Yeah. Asked and answered. Move on. I have actually personally watched attorneys argue and insist that the question was answered. A yes or no question was already answered, okay? And they will argue for 5 to 10 minutes instead of just taking 2 seconds and telling you what the answer was. They would rather, because when you get into this trap of asked and answered, 99, if you're in traffic court, he has not answered that question. Any rational adult would just say, oh, he answered the question already, move on. And you can say, well, objection. No, he didn't. What if he answered the question, what was it? And they would just say, okay, he said X, Y, Z, especially when you're dealing with leading questions and it's just yes or no. This is why I talked about the other day on the phone. We had the IRS agent on the phone last week where I already answered the question. She spent 5 minutes or a few minutes going back and contradicting me. And I just said, you know what? The only thing I can do is assume that your question was your question. You answered the question with a yes. And I'm going to assume that, and I'm going to ask a follow-up question. Anyway, but here you just got reamed with a typical lawyer trick, asked and answered, and that's to cover up the fact that they never answered the question. So yeah, I would say just on what you reported,
it's a major due process violation right there.
Yes, because it's denial of effective cross-examination, and the judge was being misleading. He misrepresented the record because he never answered the question. So when this was said and done, did the judge just end the trial there and declare you guilty?
Yeah, basically, because he asked, do I have any defense? Do I have any facts? Okay. Do I have any facts to prove that I'm innocent? And I'm like, I said, objection. The burden of proof is on a cop. He's the one that making a legal determination that the laws apply to me, which he has not presented any factual evidence of jurisdiction. And he was like, the Commonwealth don't have to prove jurisdiction. I was like, objection. I was like, when I said objection, what else I said? Objection. I was like, I'm basically I kept saying the same thing. Like, you assuming a burden of proof for the cop, And he was just like silence. I was like, you know what? I said, basically he just already assumed me guilty, so I can't, defend myself. I just appeal it to the superior court. Man.
Yeah, well, you see, did he actually say, let me see if I want to make sure that I heard you right. Did he say that they did not have to prove jurisdiction?
Yes, he said, when I said like the cop had to prove jurisdiction, had the evidence to prove jurisdiction, he was like, the Commonwealth don't have to prove anything. And I was like, that's when I was like, objection. Now remember, I said, objection. Who is the Commonwealth? What do you mean by the Commonwealth?
Oh, dude.
And,
No.
and he just went into
Roy, my dude. Whatever the kids are saying today, no, you had the judge in a solid contradiction, because before you even started with the cop on the stand, you asked him if you went through the questions and you asked if jurisdiction was an element of the charge. He said yes. The prosecution. Now, this is not just something that, again, this is not something I'm making up here. The prosecution bears the burden of proof to prove every element beyond a reasonable doubt. That's not something I made up. That's not a conspiracy theory. That's not owning the libtards, whatever anybody wants. Okay, that's just the way their system goes. And this judge contradicted. So I think a better thing would have been to have done there is say, objection. Didn't you say at the beginning that jurisdiction was an element of the charge? And then
I know I wasn't. Yeah, but I wasn't even thinking at the time because I already lost. I was like, oh, whatever. But I did ask for the record, the transcripts of for the court hearing. So that way I can take it to the Superior Court and show them where the contradiction was.
Yeah, I'd like to see a copy of that transcript myself and do a separate show and analysis of that, because for you and everyone, the reason. Look, there's a reason why I suggest, and you can go back all the way to Adventures in Legal Land, which someone pointed out yesterday was 2003. Whoa. Where I point this out. We're writing these things down because a lot of what we're going to be writing down, these are important things, we're going to be able to use later to show that there's a contradiction. And so that's why we write these important things down. And when it presents itself here, where the judge is bending over backwards to help the police officer out, we're able to, not that it may necessarily change anything. I'm not saying, it might, but it might not. When we point out through an objection, didn't you already rule that jurisdiction was an element of the charge? And he might just shout you down. He might just like you, silence. He might pull something like that.
Yeah.
But we got to take the objection because now we preserve the issue for appeal. Where the judges look, this judge, what he did was not only carry the burden for the prosecution, he lied about the police officer answering a question already. Those are two big ones. So denial of effective cross, falsifying the record, and not holding the prosecution to the burden of proof. This should be a slam dunk appeal, but more than likely they may just order a new trial since you're in Pennsylvania. You might just get a trial de novo out of this without having to make any argument.
Yeah, because when I walked out the court, I walked behind the cop and I told the cop, I was like, yeah, it feels good to be part of the good old boy club, don't it? And he was like, you're going to assault me because you lost? I was like, I ain't assault nothing. I was like, the judge had your back, so that's why you sitting up there smirking. I was going to call him a bastard. I'm like, nah, I'm in the courtroom.
Nah, we don't.
And I was like, I was arguing him down. I was mad, and I was like, daggone well, you had no facts to support your claim, and you just like, I was like, whatever, man. He was like, you want to get on the elevator and talk about it? I said, hell no, I ain't getting on the elevator with you. You have a gun, but you might try to do something to me on the elevator. So,
yeah, I
just let him have it.
I think if I was going to say something to the police officer, because I've learned my lesson, the last time I did that when we got out of court, and I had essentially won. I was found guilty, but Judge Garcia zeroed out the fine. So, I take that as a win. If I walk away without any penalty, I did pretty good, right? And so I started questioning the police officer when we were getting out there. And he was with a partner who was a real young gun. I mean, this guy probably just he was probably just kicked out of the Marine Corps. And I was just asking some questions. And I was being totally respectful. The men did have there was a 2-0 ratio with guns. I had nothing. And his partner really started getting upset and put his hand on his gun and said, "Why don't we arrest you right now for disorderly? How will we get you on the D&D? You know, whatever that they phrase." And so that's when I realized, oh yeah, bunch of cowards. Don't worry, I'm out of here. I think if anything, I would have said to this police officer, let me ask you a question here, because things things go fast at trial. Maybe I was wrong. Did you really answer my question when I asked you for the facts that your legal claim was based on? Did you actually answer that question? And he might say, yeah. Well, what was your answer? Because I obviously I missed it.
Yeah, because it was just upsetting because, like I said, the bailiff was laughing at me, the cops smirked, the clerks in the court was laughing, smirking too. They knew what the judge was doing to me. They knew.
Well, they've probably seen it, a few dozen times. They know how it goes. So it's unfortunate it went that way, but I think we can learn a little something. And you're probably going to get you probably get a trial de novo and not just a straight appellate review of the record. That's typically how these minor things go in Pennsylvania. So you just get a do-over.
Okay, yeah, because basically, hopefully, I get a fair and meaningful hearing, and hopefully, when I bring up ask the officer for facts of jurisdiction, and I can get a fair trial, and if he can't prove jurisdiction, hopefully they dismiss the case.
Well, you could then just take a nod from Trump's, the impeached president, Trump's lawyers, and just say, look, look, there's no evidence that I did it, but even if I did, I thought it was in my own personal interest. It was in the interest of the public, and it's okay. There's nothing wrong with that. It's okay. But I'm going to talk more about that later. So, we'll get the notice of appeal in. I don't pay attention to these people, even if they say it's 30 days. I still file it within the 10 days because historically it's always been 10 days. So there may be jurisdictions that have expanded that to 30 days. I tend not to trust them. And you got to be skeptical because you can't turn around and say, well, the clerk told me 30 days. They're going to say, what are you taking legal advice from a clerk?
Sure. Yeah. So I'm going to go back up there next Thursday and turn in the appeal and pay for the Superior Court to see the case, and I'm also going to file the other motion you sent me for the turnover the judgment. Which I know it's denied. So
a petition for post-conviction relief. So if it's automatically that they order a new trial, then chances are that it'll moot that, but it's still worth filing.
Okay. All right. Thank you, Mark, so much. But I just got to let you know what happened. And, and I'm learning from it. It's good that I'm going through this because I learned from being hands-on. So the more I go through this, the more I'm able. It's like training, basically. Yep.
It's like boxing. You gotta learn the moves, but you gotta actually put the gloves on, and you gotta go against somebody that and mimic those moves and make it automatic so that you know how to respond. And it's just like with you can, like with guitars, right? You can learn theory. You can learn that stuff, and you can say that if you start a major scale on the 6, now you've got the minor. Until you actually pick up the guitar and start playing, it doesn't do you any good.
But thank you, Mark, so much. I really appreciate your help, and I hope you got my donation. I donated to you on PayPal, so hopefully you received that.
Well, I appreciate that. Thank you very much.
You're welcome. Have a good weekend, Mark.
You too. I appreciate the call, and any other questions, don't hesitate to email. We'll get you through it.
All right. Thank you, Mark. All right. Bye-bye.
Appreciate the call. It's Roy in Pennsylvania. Yeah, it's very, very important. I know things go fast. I know they deliberately try to go at a breakneck pace, and that is to make it a lot more difficult for us It's a lot more difficult to call them on things, especially if you've got someone who's doing a Gish Gallop. Not the most common thing in court, but they can still throw a bunch of stuff at you. And so we always have to keep notes. I wouldn't necessarily go in and ask all those questions unless I knew I had a judge that has some patience and has some professionalism, so I can get through that. I always go in under the idea that I have to go for the throat and go right for the foundation of the prosecution's claim, as opposed to being able to get process questions in. But I'm glad he did. And so now if he does get review, yeah, the judge admitted the obvious. Jurisdiction is a trial issue, yeah, and it is an element that has to be proven beyond the reason why it's a trial issue, not a trial issue only, but the reason why it's a trial issue is because the prosecution has to prove it beyond a reasonable doubt, which is something that is remarkable when you think of the case of the guy in New York that was falsely convicted for murder, because they could not prove beyond a reasonable doubt the guy was actually in New York at the time. He had he had physical evidence proving he was in Florida. One of the few times it's better to have been in Florida than in New York. He had physical evidence proving he wasn't there. They had no evidence whatsoever that he was in New York. Couldn't prove that element beyond a reasonable doubt. They still convicted him. So when you hear things like this, well, Mark, should I get a jury or should I have a bench trial? Oh, judges might be corrupt, but they're not dumb as stumps. I can't say, and I won't say that judges are dumb as stumps, because they're not. Judges are a hell of a lot more intelligent than your average jury member. So, what do you got? I don't know. All right, we'll get another call, and then I can get into some of the other stuff. Hopefully, we got some good news over here. We got area code 209. You're live on the No State Project. What's your name? Where you calling from?
Hi, Mark. This is Mike. I'm in Northern California.
Hey, Mike. Is this the Mike that I've known for a couple of years?
Yes, sir.
It's a little more difficult to it's not the best connection there, and it's a little low. Maybe I can punch up your audio there and I can hear you better. But since you coughed there, I think I recognize that.
Oh, okay. Well, I'm still dealing with this tax issue. And basically what's happening is, we are requesting what do you call them? Like a trial or some oversight or something, and they are simply ignoring everything that we are requesting.
Yeah.
Except the only thing that they are not ignoring is the fact that we will put a lien on your property.
They will put a lien on the property, and then they will start a situation where they're leading to a county auction, and that is
correct.
Correct. And that is
the payment.
Right. That's why it's unfortunate in these situations, because of what they do and how fast it goes, and because you cannot file in court. Well, you can, but you have no remedy to stop them in court because the Anti-Injunctive Tax Act. And it doesn't matter how much evidence we have. It doesn't matter how many admissions. The courts will not even acknowledge that there is a narrow exception. Yeah. At least I know it's a narrow exception. It's not, but so we have to pay, and then we have to request the money back. Now, just for a little bit of background for people, there is no administrative process available most places, because especially California, the only thing you can discuss in California is the assessed value that the tax assessment is based on. That's all they have jurisdiction to determine. So it's fine if you're playing it that way. Yeah, get your administrative hearing and show that the assessor is not accurately assessing the current market value of the house. There's nothing wrong with that. But we're not doing that, so that process isn't available. So we have to pay, request to have the money back, and if they don't within, let's say, 6 months is reasonable, file a claim for damages against the county to get it back.
Okay, well then, I guess I'm going to have to just wait a little bit and do that a bit later on, because they, other than making threats against my property, then they are completely ignoring the request to have a hearing of this issue. They just refuse to do anything at all other than, okay, either pay or we're going to take your stuff.
Well, yes, to be more precise, and what happened was they wanted their counsel. They did not want to answer questions without their county counsel or attorney being present. And they refused to set up that conference call so that we could discuss it. And to me, that's just evidence of bad faith. So we can show that not only by their own admissions, and we have them, that they can't support their foundational legal claims, but when we tried to exercise good faith to get it resolved by following their protocol, they were the ones that said, well, I'm not going to answer any questions without counsel. And then they refused to set up a call with counsel. That seems like it's pretty solid evidence of bad faith, that they were just misleading us and had no intention of dealing with us in good faith. So we could just use that as evidence against them if you have to go to court and sue to get the damages.
Well, if you can, possibly help me out a little bit in the future with how to deal with bad faith. I mean, that's what we've got going on here, actually.
I think I've already kind of covered at least part of what we can do about, we deal with the bad faith by using against them to support our claim for damages. If they're judges or they're lawyers, then we could file claims against them with the Bar Association. But, those tend not to go. So there's very little else that we could do as far as the bad faith. Now, we could try to go up the chain of command and try to find somebody that will deal with us in bad faith. I personally would just rather have them say, look, and they do this. To me, this is more honest. Mike, if they just said, look, we're not going to deal with you. I'm not going to answer your questions, and I'm not, instead of lying and say, well, we'll have to do this with counsel. Just tell us straight out, we're not going to work with you. Okay, I can respect that much honesty. And then but as far as what you're saying, what can we do to deal with such bad faith? Other than what I'm suggesting and maybe a complaint to the bar, there's not much else we can do. I mean, like with the IRS, for example, we file TIGTA complaints to the Treasury Inspector General for Tax Administration for violating, let's say, false statements, Title 18, Section 1001. But that's very little that we can do because there's almost nothing that's ever going to happen from that. So other than using the evidence of bad faith against them in court or in an administrative proceeding, there's not much else we can do. I mean, you can make a stink about it. You can go to the county commission and you can air the bad faith there so that the public can hear about it. That's something we can do. So at least this is what gets me about people like Stephen Myrie that I talked about on that show yesterday. It's getting their names out there, getting their face out there so that they're not doing these immoral, unethical, and yes, illegal things with a veil of secrecy. That maybe that, something, I don't, you hope that maybe someone on the county commission, or if it's a city council, like one of them just says, whoa, hold on a second. They did what? But other people in the county might hear that, and that might be enough to get them to, deal a little more fairly with us.
So would it be fair to assume that counsel not returning calls or not wanting to set up a meeting of any kind, that they are simply avoiding that aspect of it that, okay, now that counsel is involved, we can, go after counsel.
Well, that's why I mentioned a complaint to the bar for an ethical violation. You can name counsel on, as an actor that contributed to the damages. Yeah. In a suit against the county, you certainly, once you file suit against the county for damages, you can include them as witnesses, and you can put the county under and ask them why. See if they have any good faith defense to that can be proven. But there's very little we can do generally against attorneys. Prosecutors, there's nothing we can do. Now, I mentioned with Stephen Myrie. Probably in my how angry I was at the time of what he got away with. Here, it's a situation where, unlike most, there's a judge who ruled on the record that he was engaged in gross prosecutorial misconduct. The Bar Association in Nevada would take that complaint seriously, and maybe it's not too late to do that. I don't know. It's something I have. I would personally file a complaint against that guy. But the best we can usually do is have them as being actors who contributed to the damage, but going after them directly, that's usually not going to work out too well, even if you've got the facts and and the law on your side. Because even if you do get into court and you have a good cause of action, the fact is that by the time you could even get that to trial, they've probably bankrupted you already, and it's 5-10 years later.
Okay, so I'm sorry.
I got you speechless with that.
All right, Mark, I'll let you know if you can get another caller.
Well, I wish I had more for you, but have you, before you go, I'm trying to remember, did you already file a request to have the money given back?
Yes, I did.
Okay.
Actually,
that's what I thought.
Kind of just cut I mailed that in with the last payment.
Okay. All right. Well, so I would wait my 6 months, do a follow-up, and if they're not going to give the money back, I would ask for the grounds in writing, and then I would file a claim against their insurance.
Okay, there you go. All right. Thanks very much, and we'll be in touch, and keep up the good work.
Well, I appreciate that. Thanks again, Mike. Appreciate the call.
Thanks.
Yeah, we'll see if we get any more calls, but I'm kind of winding down in time, and I can't go over today. And I mentioned the Stephen Myrie thing, and I've spoken, for years from the very beginning that there's a pretense of fairness that these people put up. That even though they're doing things that the average person would go to prison for. So if I or you, if I was to force my community, people in my community or another community, to give me money, even under the guise that I was going to do really good things for them with that money, I'm still a criminal. So that there's this pretense of fair. Well, it's the government and they're doing it for the public good. And the people voted them in. And we're not going to look at how they came to power, just that they're in power. And if you're of this mindset, if you're of this damn anarchist mindset, we're not even going to let you stay here if you're an anarchist. I mean, I've mentioned on the show many times that I'm a hardcore genealogist. It's one of my favorite things to do after playing out their guitar. And so I see a lot of naturalization documents, and it says you cannot even put in a petition for naturalization so that you can stay here if you're an anarchist, meaning you don't believe in rulers, you don't believe in having rulers, that you have this mindset that that no one has a moral right to be immoral. You have the audacity to believe that basic principles of right and wrong apply to everybody. And you can't stay here Because that's what an anarchist is. That's what we are. We call BS, even if it's a sacred cow. Oh, you can't go look behind. You got to accept that the law is. You have to accept that the law applies to you. Again, we've been advised on this show, not by me, by a critic. You have two choices if you don't like that the laws apply. Two. Vote them out, kill them. That's it. Other than that, the laws apply. There's no evidence for that. There's not a single shred of evidence. So it's this pretense of fairness that you see. Now, we're used to seeing that in traffic court. We're used to seeing that in the federal court, especially if it's the IRS. You look at someone like Stephen Myrie, who I've reported on a show. If you're not familiar, please do yourself a favor. I went really in depth with this guy a year or two ago, at least maybe 2 years ago. He is a serial offender for prosecutorial misconduct. He is the reason why the Bundys got acquitted, or there was, or the case, the charges were dismissed. He withheld valuable information, exculpatory information and evidence from the defense, including FBI surveillance and statements that the Bundys were not dangerous. This is huge. I mean, that is a huge thing. When you're trying to say that somebody is a domestic terrorist and your own FBI is saying they're not dangerous, and you withhold that. And so you see the pretense of fairness comes in with Judge Navarro, where she throws it out. Why? Because I got caught. I say it's a pretense of fairness because if Judge Navarro really cared about right and wrong and fairness and due process being that there's a notice and opportunity to defend in a meaningful hearing, she would have heavily sanctioned Myrie and his team. This man, according to Judge Navarro, and it was like a year investigation into this, he lied directly to Judge Navarro. So what does Judge Navarro do? It's great she threw out the complaint. That's the pretense. Because if she was really serious, if she was caring, if it wasn't just a pretense, Myrie would still be in jail. What did they do to Stephen Myrie? They demoted him. You come up $1 short at the fast food restaurant down the street, you lose your job. This guy lied to a federal judge multiple times, withheld exculpatory evidence, covered it up, got caught, lied about it, and he got demoted. He's still on the job. That's a pretense. And now, at least some of them, they try to make it look good. But now you see what happened yesterday or this week, where you've got Moscow Mitch McConnell, Lindsey Graham. I'm not even pretending to be fair. I'm not even pretending to be. They say, I'm not even pretending to be fair. They voted against having witnesses, and Trump, the impeached president's lawyers, lied every step of the way. Every step of the way. I have to finish before I get a call. Every single step of the way. See, it's I always said that our job when we go into court, my job to get this thing thrown out is to strip away, to knock down the pretense of legitimacy, right? You've all heard me say that. The legitimacy, the pretense of fairness, that it can't be fair. That is the rationale behind the question, am I entitled to a fair trial? Can I get a fair trial if there's a conflict of interest? Who do you represent here, Mr. Lawyer with the robe on? See, we're bringing out the contradictions. We're bringing out the fact that the judge is literally representing the same party. But here, Moscow Mitch and his cult of Republicans, look, I'm an anarchist. I'm not a Republican or a Democrat. I actually, unlike, I wasn't believed on the show yesterday. Pete Santilli didn't believe me, called BS as soon as I was off the air. I really don't have a favorite there. I am not a Republican or Democrat or an independent. I look at what the facts tell me. They beat me to it. I didn't have to do anything to destroy the pretense of legitimacy. Moscow Mitch and the rest of the cult of Republicans did it. The idea that you can have a trial without a trial. Now, if you have a complaint that is filed on the civil side, and there is no dispute to the material facts, there's no genuine issues of fact, then the judge just has to make a legal determination if the facts justify the relief. And he can do that because there's no genuine issue of fact. There's nothing for a jury, a trier of fact, to decide. But here, for them to claim that there have been witnesses is false. There were witnesses in the investigation. Now, you can argue, well, if they've already done the investigation, why would we have to put witnesses on the stand? Because the moment the impeached president and his lawyers disputed the facts, and they did, Sekulow, all of them, they say that the facts are not in dispute. That's not true. The moment they disputed the facts, you require witnesses so that the jurors, in this case, the Senate, can determine what's true and what's not. But they threw all that out. For the first time in American history, they're having a so-called impeachment trial with no evidence no new evidence. You don't get to dispute the facts and then not have witnesses. That's just not how due process, it's not how trials work. The Supreme Court of the United States has said the sine qua non, the be-all, end-all of a trial is the cross-examinations. Because that's where the evidence is actually being challenged. But instead, they get to lie. The president, the impeached president, he didn't get due process. He couldn't cross-examine the witnesses at the investigation stage. Actually, they were allowed. They chose not to. See, and for those who may be on the Trump train, the way the due process works is in a court proceeding, when you have an indictment, that's strictly from the prosecution side. They're making their case to see if there is sufficient evidence to have a trial. Nobody gets to cross-examine the witnesses in a grand jury investigation. Well, certainly not the defense. The defense is not even allowed to be in there. So lie after lie after lie. And then it comes out that Cipollone, who might be Paisan, was actually involved in the scheme to shake down Ukraine. And members of the impeached president's legal team have donated to Senate elections. That is a scam. That is a sham. And so for those who may not, who say, well, the House this, the House that, I'm no fan, but you got to look at the facts. Impeached President Trump admitted to what he did. Impeached President Trump's acting chief of staff, Mick Mulvaney, admitted it. So you have See, this is you have some politicians, most politicians are criminals, but you have some trying to maintain that pretense of legitimacy and fairness. And then you've got these Republicans. And you have Lamar Alexander admitting the House made their case. He admitted it. The House overwhelmingly established that Donald Trump did wrong. It was wrong to hold back the funds. It was wrong to try to get an investigation into the Democrats. It was wrong. They admit that the House made their case, but they're not going to hold them accountable. So on one side of this, it is what the impeached president and the cult of Republicans are doing. I would hope that one of the benefits, if any benefit from this, is that there will be so much distrust in government. There will be so much, interest in the legitimacy of government itself that we can add more anarchists to the rolls. That more people see through this sham, because even when you have politicians who want to do something to hold these criminals accountable, because look, the former governor of Illinois, he went to prison. He might still be in prison. The impeached president's lawyer is in prison. Mike Flynn is his national security advisor in prison. Paul Manafort is in prison. So politicians, and Dennis Hastert, prison. So hopefully from this, we can see more anarchists where people, and there's more of an examination on the legitimacy or illegitimacy of government itself. That the only way to have any accountability whatsoever is to take away the taxing power. No more compulsory support. That's where all this comes from. The fact that they can do whatever they want and not be held accountable for it. Nothing. Trump will be long dead from a heart attack before he's ever held accountable, even if they wanted to hold him accountable at the state level and the federal level once he's out of office. He'll be dead. The guy's 73 years old. He eats nothing but junk food. The man is not going to make it to 75 or 76 years old. He's going to be dead. He's never going to be held accountable. So anyway, we'll try to get to one last call before I'm totally out of time. But I had to say what I planned on saying about the title of the big broadcast here. So I hope we can say that after this sham from Moscow Mitch, that we have, it's creating more anarchists. Area code 804, you're live on the No Stay Project. What's your name? Where you calling from?
Well, my name is Bert, longtime follower, calling from Richmond, Virginia.
Oh, well, welcome back. Welcome to the show and from Virginia. What can I do for you today?
This isn't like your typical fare, but I'm going to be fighting a ticket on the 4th. It's a expired inspection sticker ticket. But here in Virginia, we have this thing called uninsured motorist fee. And through DMV, you can give them some money. And you don't have to carry the insurance, because I don't involve myself in those Ponzi schemes. And this also exempts me from having to have my vehicle inspected, because if I'm responsible for any damages I cause, I'm also responsible for the care and maintenance of my vehicle. And I was looking back at the Enabling Act, and it was, just to ensure safety. I'm wondering, what do you think about that?
Using the Enabling Act? How so?
Well, I just looked to see what they thought gave them the authority to force me to have the sticker in the first place.
Oh.
So I was looking back at what they think the reason is that I have to have it, and I'm kind of using that against them, because I am a mechanic. The care I perform on my own vehicle is way above and beyond what state maintenance requires. to take my vehicle right now, it would pass inspection. But I don't know. What I want to do is find out what I can say in the lower court that I can bring into an appeal.
And you think that all right. So
I'm pretty sure they're just going to say. I'm pretty sure they're just going to find me, say, court costs, get out of here. But I want to appeal it to a higher court because I'm pretty sure that they don't have the authority to have an uninsured motorist have that state inspection.
Okay, but what's your actual argument? Because you're maintaining the car better than the average person because you're a mechanic. I don't see how that's going to fly.
Yeah.
Yeah, I wouldn't defend on that particular ground. The way I would go is I would hammer away at the foundation that their claim is that the laws apply because you're physically in Virginia. There, I would attack that as opposed to that, because when it comes to something like that, if you're going to argue that the way you are, they're going to be very loath to try to carve out a new legal exception. And being that you're a mechanic, I don't see that the appellate court is going to say, yeah, the guy's got a good point. He is a mechanic and he's going to do a better job of. I don't see any that you could have success with that.
Okay. Could you maybe give me some tips for what I might ask to that would be helpful in the appeal?
Well, you look at what happened.
I'm pretty sure that, say I'm guilty and try and squeeze money out of me, but I know it's just a traffic court.
Yeah, I would look at it. I don't have the time to get into it, but if you listen to the call that we did with Roy, we went into a lot of detail about what happened to him and what would probably happen in a situation, because you're in a similar situation and traffic courts go by the same usual, they do the same stupid things. You can look at something like a denial of effective cross-examination, which judges are more than happy to give you because they're bending over backwards to help the police officer. I mean, that's what they do. So that, I think you have a better shot. But as far as changing the law, because I don't think not on the grounds that you're presenting. I don't think that's going to fly. But if you are looking to defend against it and have something that if you have to take to appeal, then I think a denial of effective cross-examination is a hell of a lot better. And I know for a fact that it is a very solid legal argument that as long as you have the facts to support it, and a judge willing to, equally apply the law, then you stand a pretty good chance of getting that reversed. If you, but changing the law or carving out, no.
We have several exceptions here already. That once a car is considered antique, 25 years old, it is no longer required to have that. I don't fall under that, but I'm 2 years away from it.
Right.
Police cars don't have to be inspected because there's any state-owned vehicle or whatever. Yeah. They don't fall under the same guidelines that non-state or government-issued vehicles do.
And federal vehicles don't have to.
Correct. Yeah. So there's already these niches where they don't have the requirement, and I'm believing I fall into one of those because I'm an uninsured motorist.
I don't see you having success with that. I don't think you're going to have success carving out.
I don't think that's what it is there, but the connection is that these state inspections are mandatory because the greatest part of the population doesn't know how to maintain their vehicles.
Yes, but
it's there to create
I get your reasoning behind it. I just don't think it's going to be persuasive at all in the court. So,
all right.
I wish I had.
Well, I am real familiar. I'm real familiar with your, the laws don't apply because, well, they just don't apply. There's no proof of it.
Yeah, right. Exactly. There's no proof. Well, I am totally out of
Exactly.
time. I do need to run, but I'm glad I was able to take your call.
Thank you so much, Mark. I love your work. I've been following you since it's Ventures in Legal Land. You recommended I read 3 felonies a day way back in the day, and I did.
Wow.
It was a good read. I hadn't heard you bring that up in a long time.
Well,
I love you, man. Thank you so much for what you did.
I appreciate the call, and good luck. Let me know what happens on the 4th.
Thank you. I will.
All right. Appreciate the call.
All right. You have a wonderful.
We got Bert in Virginia. I think it was Bert. I hope I didn't screw up his name. That would be incredibly embarrassing and unprofessional. But it was a little more difficult to hear. But I wish him luck. I wish I was doing a show next Wednesday and next Saturday. But the next week I will not be in Arizona, so I am taking. I won't be able. But I will do my best to get the success story videos up. So we got a little bit of new material, but there's a lot of shows still on that I know not everybody's watching every moment. So there's a ton of material and court procedure and stuff in all the shows. So definitely check out shows that you haven't seen yet. So, and if you are being attacked by a bureaucrat, markstevens.net. My Government Data has a whole model that's proven over these years to be effective at getting these tickets thrown out. So appreciate everyone tuning into the big show today. I will not be live the next Wednesday and Saturday. So that following Wednesday, mid-February, I guess, I don't know what day it'll be. It's only February 1st now, but a week and a half, or maybe February 12th or 13th. Anyway, either way, I'll be live again on the second Wednesday there. So, hey, until we're back live again, salud.